A well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. Welcome to another edition of Bearing Arms, Cam and Company. My name is Cam Edwards. Glad that you've joined us on the program today. Coming up in a matter of moments, we're going to talk with Mr. Chuck Michel. He is the president and general counsel for the California Rifle and Pistol Association. We're going to be talking about a case out of the Ninth Circuit Court of Appeals. A case, I guess, that's been in, it's not out of yet. In fact, it is still in the Ninth Circuit Court of Appeals. The case of Duncan versus Becerra, a challenge to California's magazine ban. That's right, ban on magazines that can hold more than 10 rounds. Originally, this ban was put in place, I believe, back in the 1990s, and there was a grandfather clause, so you cannot buy a magazine that could hold more than 10 rounds of ammunition. But if you owned one, you could keep it. That changed a few years ago. California lawmakers decided that no. Actually, even if you've owned these magazines for, well over a decade, we want you to get rid of them. Yeah, either take them out of state, either hand them over, but you can't keep them. That law was challenged, and a U.S. District Court judge ruled that the ban was unconstitutional. The case was then appealed by the state of California up to the Ninth Circuit, where a three-judge panel affirmed that lower court decision, ruling that California's magazine ban violated the constitutional rights of Californians. Now the Ninth Circuit is going to take another crack at this. An en banc review has been granted, which means a broader panel of judges on the Ninth Circuit will reconsider this case. Ultimately, of course, the goal is to get this case to the Supreme Court. But we're going to talk with Chuck Michel about what this en banc decision might mean, as well as a couple of other cases that are still percolating in the Ninth Circuit. You've got Rohde versus Becerra. That is a challenge to the background check requirements on ammunition sales in the state, as well as a ban on Californians actually buying ammunition out of the side of the state of California and then bringing it in to the state. We may even touch on the case Young versus Hawaii. That's not a case that Chuck is involved in. He's not the attorney of record there, but this is another Ninth Circuit case. We've been waiting more than 100 days, actually, for the Ninth Circuit to issue its en banc opinion in Young versus Hawaii. That case deals with the right to carry, specifically challenging Hawaii's ban on open carry without a license that the state of Hawaii does not give anyone. And so in essence, with concealed carry and open carry theoretically allowed, but practically speaking prohibited, this may be a good vehicle for the Supreme Court to weigh in on our right not just to keep, but our right to bear arms. So a lot to talk about with Chuck Michel. Let's get started. Take a look and a listen. Hey, Chuck, thanks so much, sir, for coming on the program. It's good talking with you today.
Always a pleasure, Cam. Glad to be here.
And there's no shortage of things to talk about, but let's get started with the Ninth Circuit's decision to rehear the Duncan versus Becerra case. This is the magazine ban challenge in California. Was this expected? Were you anticipating any other decision other than the Ninth Circuit saying, all right, we want to take another look at this?
Well, we were hopeful, but realistically, there are some leaders on the Ninth Circuit Court, Justice Thomas among them, who really have been very, very active in fighting against any expansion of Second Amendment protections. They want to basically give us a Second Amendment with no teeth, and all of the decisions that they've handed down so far have effectively advanced that sort of an agenda. The refreshing thing about the three-judge panel ruling in the Duncan case was that they finally saw the light, so to speak. They recognized that the government should be held to its duty of proving that a law that restricts your right to keep and bear arms has to actually accomplish something, and the government's the one that has to prove that it does. So we were hopeful that they would recognize the wisdom in that three-judge panel ruling, but not surprised when they didn't. And so now we'll see what happens. It's not a foregone conclusion that we'll get so many hostile judges that we won't be able to win in the Ninth Circuit en banc, because Trump administration has changed the balance there fairly significantly. But I'm afraid that it is going to come down to sort of the luck of the draw on what 11-judge panel we get for the en banc hearing.
Yeah, and as you say, the Ninth Circuit is not the court that it was 4 or 5 years ago. There is not quite 50-50 parity between Republican-appointed judges and Democrat-appointed judges. And, of course, you have some Republican-appointed judges who've, gone against the desires of gun owners. You've actually had, some Democrat appointees that have been able to treat the Second Amendment as a real right. So, but again, as you say, the balance certainly looks a lot better than it did a few years ago. But as you say, Chuck, obviously your position is the magazine ban is unconstitutional. California's position is, well, no, it's not. So now we get into the question of, all right, well, how do these courts decide whether or not these laws are an infringement or an unconstitutional burden on the part of gun owners? And then it gets back to, what standard of review is being used here, right? And this is something that the Supreme Court has, we've heard from, folks like Justice Thomas, Justice Gorsuch, Justice Alito, that these lower courts are misreading the Heller decision, they're misreading McDonald, and they're basically taking an approach that approves every gun control law under the attitude of, well, if the government wants it, they must have a good reason for it.
Yeah, this was Justice Scalia saw this coming in the Heller decision when the dissents in that case argued for some kind of a watered down standard of review. And he said, that's not going to fly. You can't do that. So he rejected sort of an intermediate scrutiny standard of review that was proposed in the dissents in the Heller decision. But effectively what we've got is the standard of review that was being advocated for by the dissents in Heller, a watered down standard, but it's just been given a different name. So now it's the same kind of interest balancing test that Scalia warned against, where judges can basically put their finger on the thumb, or their thumb on the scales, I should say, of the decision, and just find that they're that it's outside the scope of the Second Amendment's protections to begin with, or that when you do some interest balancing, public safety outweighs everything. I mean, it's just very easy to manipulate. And Justice Scalia saw that in the Heller decision. But we've been fighting for, since 2008 to get the courts to respect what he said and to apply a standard of review when you're considering a constitutional challenge to a gun control law that actually respects the Second Amendment and doesn't treat it like, as Justice Thomas said, a second-class right.
Yeah, and in terms of that interest balancing test in the Ninth Circuit, states like California haven't even had to prove that there actually is a public safety benefit. All they have to do is claim that there's a public safety benefit. I'm thinking to the microstamping challenge in particular, where this is a law that manufacturers literally could not comply with. There's no evidence that it had reduced violent crime. There was a lot of evidence that it had reduced the ability of legal gun owners to acquire commonly owned firearms elsewhere across the United States. And the Ninth Circuit basically just said, well, it doesn't even really matter if it's a bad law. If it's a bad law, they can always repeal it. But they say that they need it, so we should let them have it.
Right. This is a huge problem in all litigation against the government, is this deference. This acceptance to government findings, blind acceptance of government findings. You don't question what the government says its rationale for a law is, and that's exactly what is supposed to be different about a constitutional challenge, or a constitutional challenge to a law. You're not supposed to take the government's word for it. The government has to prove that what it's saying is, for the justification for any given law, is true, and that the law will actually accomplish something that is a public interest. And they've been just given a pass on most of this stuff. The courts do not look at it carefully enough, and that's what's so refreshing about some of the jurisprudence coming out of California from the San Diego court and now from the Ninth Circuit. They're actually applying they're holding the government to its burden of actually justifying its actions. And they're looking at its evidence and saying, nothing here shows that this policy that you're advancing is justified. So, they say, the government says that magazines that hold over 10 rounds have no self-defense value. Well, wait a minute. They're used all the time to defend people. The reality of exchanges of gunfire in a self-defense situation is that you often need more than 10 rounds in order to effectively defend yourself, even from one attacker, but certainly from several. And so that's the kind of thing that courts would just close their eyes to in the past and say, oh, well, if the government says so, then we're going to accept it. Well, no, that's not how it's supposed to work. And that's what Duncan stands for. So we'll see what happens when we get 11 judges having a look at it. But if that doesn't work, ultimately the Supreme Court has to take a case to reset the test, to reset the balance of what's going to happen with the standard of review on all these cases. It's that whatever the Supreme Court says is going to dictate what the appropriate review is for Second Amendment cases for decades to come, which is why it's so critical and so good that we have, I think now, even without Justice Roberts, who was kind of a wobbler, a strong 5-justice majority that on the Supreme Court that respects the Second Amendment and will give it the teeth that it deserves to have to stop governments from passing laws that they just can't justify, but that they want to, they want to hold a press conference and say they did something.
Yeah. Well, and to that end, this isn't a California case, but in just a few weeks, the Supreme Court is scheduled to hear in conference New York State Rifle and Pistol Association versus Corlett, which is a challenge to New York's licensing regime. And I thought it was interesting. I was reading the brief from Letitia James, the Attorney General of New York, to the Supreme Court. And basically she argues, look, there is no split in the circuits. Everybody agrees that there is a right to carry, but the difference between, let's say DC's Court of Appeals, which struck down the district's good cause requirement, and the Second Circuit, which has upheld New York's good cause requirement, she says is that the licensing regime in New York is not nearly as restrictive as it was in Washington D.C. And so I think you've got two issues here at play. First, as you talk about, these lower courts have abused the standard of review. So even when you find courts in agreement with one another, it doesn't mean that any one of those courts is making the right decision. And in fact, they're just sort of aiding and abetting each other in using that lowered standard of review. But secondly, this idea that, well, because our law looks a little bit different than DC's law, then there are some sort of fundamental differences here. There is no fundamental difference. I mean, you can go back to the Peruta case in California or the Young case that's currently in the Ninth Circuit. All of these issues when it comes to the right to carry basically boil down to, can the average citizen carry a firearm for self-defense? And if they can't, why is that not a violation of their constitutional rights? Right.
The test that they want to apply is, in California, for example, to get a concealed license, concealed carry permit, you need to show some kind, in most jurisdictions, of an articulable threat. Basically, you need to show, here's the death threat I got, and here's the name and address of the guy who sent it to me. So I actually have this fear for my life. Well, so almost no one has that, obviously, and so they treat it like a privilege. Only those few people who can establish that high of a threat can get a license. Well, just because in New York, maybe you don't have to have the guy's signature on the threat, or maybe it's slightly less, so a few more people get the license, that doesn't solve the problem. You shouldn't have to be under some kind of imminent threat in order to be able to get a license to have a gun, to be able to possess a gun in a situation where you might be threatened, where you might be in danger, which is essentially all of us as we walk around on the streets these days. At any moment in time, you could become a crime victim, and that's what you need to be ready for, and that's what Heller talked about. But to try and say that there's not a split, that just cracks me up, because there are some certain, They have shall issue, may issue, and no issue. And in some circuits, no issue has been struck down. And in other cases, no issue has been upheld. So that's a split. So the Supreme Court really should take that case. It's very much like the New Jersey case that was there last session that they did not take. And Justice Thomas was very adamant about how they should have. And now with Justice Barrett on there, hopefully they'll take that New York case.
Knock on wood. We will know hopefully again in a few weeks. Now, listen, before we let you go, not that you're billing this interview by the hour, thankfully, but before we let you go, I do want to ask you about another case out of California, Rody versus Becerra. This dealing with this bizarre law in California that requires background checks on ammo sales, prohibits California residents from purchasing ammunition out of state and then bringing it back to California.
Right.
Where does that case stand right now, Chuck?
That's sitting in the Ninth Circuit and probably held up because they're waiting to see what happens in the Duncan case, too. Because, again, the standard of review doesn't just apply to one case, the magazine ban. It applies to everything. But tens of thousands or hundreds of thousands of people have been stopped from being able to get a hold of ammunition or have to pay exorbitant amounts of money, several times the cost of a box of ammo to get the state's permission to buy ammunition. And when they looked at the evidence in that one, they saw that they really were not stopping bad guys from getting ammunition. They were just creating red tape to make it more difficult for good guys to get ammunition. And that's part of the game. The more red tape they can red tape a right to death. You don't have to outright ban something, basically kill it, ban it. Because if you make it so difficult for people to jump through hoops to get a gun or to get ammunition, they throw up their hands and give up. And so and that's part of the plan. They don't want people who are not, diehard Second Amendment advocates or activists. Anybody who's just thinking about, I might want to go get a gun to go see what shooting at the range is all about, or to have one to defend my family. They want to make put so many barriers in the way to do that, cost and red tape and forms and whatever else they can do, that people just, they go do something else. And then the number of gun owners dwindles and the political clout of gun owners dwindles. And that's part of the plan of the folks who really don't want to have gun owners being a political force.
Absolutely. Well, listen, Chuck, again, I really appreciate your time today, getting us caught up on what's going on here. I know we'll be calling on you in the weeks ahead. Is there anything else that California gun owners in particular need to know about? Where are we legislatively?
That's a good question. Folks really need to get plugged into the CRPA. The potential bills are just starting to come out, one of which is a huge gun tax, which we're going to be fighting. But the best way to stay informed on this stuff is to go to crpa.org and subscribe and, join CRPA, be part of the fight. We've got all these new gun owners out here. Hopefully they, as they went through the process of buying a gun, they got a firsthand look at how many hoops they have to jump through just to get a gun, and hopefully they appreciate how unnecessary most of that is, and they become politically active. And so getting involved with CRPA will keep you informed, even if you don't join. Just go subscribe and stay informed, because the California legislature, they've never met a gun control law they didn't like. And COVID may be slowing them down, but it's not stopping them. So folks need to stay informed about what's going on there and help us fight back in that rigged legislative environment.
Absolutely. Chuck Michel, President and General Counsel of the California Rifle and Pistol Association. Thank you so much for joining us on the show today.
My pleasure, Cam. Anytime. Have me back soon. Always pro bono for you, by the way.
I appreciate that, my friend. We'll talk soon. Appreciate Chuck joining us on the program, crpa.org. That is the website. They also, by the way, a fantastic magazine. You remember what magazines are? The glossy things you read, and they got fantastic magazine, Firing Line. I actually am a subscriber. I get it in my mailbox. There is all kinds of great information. So truly, if you are a California gun owner, I urge you to support the CRPA. In fact, if you're not a California gun owner and you've got a couple of bucks to kick into a Second Amendment organization that is fighting the good fight on very unfavorable terrain, I would encourage you to join the California Rifle and Pistol Association as a member as well. All right, let's get now to today's Armed Citizen story, our good deed of the day, our recidivist report. We will start there with a case out of Kalamazoo, Michigan, where a man charged with shooting a domestic violence victim has been sentenced to probation and time served. Please tell me, gun control advocates, that the answer to this is more gun laws rather than better enforcement of the laws that are already on the books. This is unreal. 24-year-old Juan Cortez Richards pleaded guilty on January the 12th to domestic violence, third offense, by the way. Still gets probation and time served. And an assault charge, along with 2 weapons felony firearms charges, were dismissed. A witness intimidation charge was dismissed as well. The agreement, according to MLive.com, stipulated that Richards, who had already served 240 days in jail in the case, would serve no more jail time relative to the charges as long as he adheres to the rules of his probation. The circuit judge in this case, Pamela Lightvitt, said she wasn't happy with the agreement when she sentenced Richards yesterday, Tuesday, March the 2nd. She said, quote, "I know that there's an agreement here, and I'm not thrilled with it." Well, who would be? I mean, other than Richards, who gets a slap on the wrist for a third domestic violence offense. Richards violated no contact orders involving his victim twice last June while he was out on bond. He was told he cannot be within 1,000 feet of the victim, her residence, place of employment, or school. He was ordered to undergo anger management, domestic violence counseling as part of the probation that he was sentenced to on Tuesday. Prior to the sentence being issued, Richards' defense attorney argued to the judge that the victim in this case had contacted Richards multiple times, stating that she had lied during his preliminary hearing and that he had filed a signed affidavit from her stating as such. The defense attorney said, "We can't look at testimony based on someone's word who then says that they're lying. Several allegations in the case could be corroborated only by the alleged victim." Well, yeah, given the fact that there was witness intimidation charges in this case, can we really be sure that she's telling the truth now? Or perhaps that she was intimidated by Richards into signing an affidavit containing falsehoods? This is just ridiculous. Absolutely ridiculous. Kalamazoo County Assistant Prosecutor Rebecca D'Angelo said it's not uncommon for domestic violence victims to recant their stories, and that doesn't mean that the events did not occur. She said, quote, "The defendant pulled out a gun and actually repeatedly shot at this victim. Not only do we have the victim's statements that were made, but there was other cooperating testimony and evidence that was found to substantiate the victim's version of events. When looking not only at his outstanding criminal history, but also his involvement with this particular victim, although he only pled to one offense in this particular case, obviously it's the people's position that a whole lot more was going on here. The defendant is not very old and already now has his third domestic violence conviction on his record. There's a problem here." There is, and I appreciate the prosecutor saying that. But I also want to know, why the hell did she take this plea deal? If in fact there was corroborating evidence that did not rely solely on the victim's statement, why offer Richards a plea deal? Why allow him to escape justice with a slap on the wrist and time served? And so far, we have not heard any explanation from the prosecutor as to why this plea bargain was offered. We know why it was accepted, but we have no idea why it was offered in the first place. Today's Armed Citizen story from the where is this from? It's from the great state of Oregon, Veneta, Oregon. A resident in rural Lane County scared off a burglar with a gun on Tuesday. That, according to the Lane County Sheriff's Office, KEZI-TV, reporting on the incident. They say the deputies arrived at this home just before 3 a.m. Residents told deputies there that an unknown man had broken into their home, had entered a bedroom when one of the residents armed himself with a handgun and chased the man out of the house. The burglar then reportedly returned to the home a short time later while the resident was on the phone with 911 and was scared off yet again. This time, the homeowner discharging a round. Deputies describe it as a, quote, warning shot as the burglar advanced on him. Suspect fled. 37-year-old Jason Lackey picked up a short time later. He's now facing charges of driving under the influence, first and second degree burglary, first degree attempted theft, being a felon in possession of a firearm, as well as unlawful entry of a motor vehicle. And finally today, our good deed of the day from Louisiana. Zachary, Louisiana, where a 94-year-old was saved after he was attacked by dogs thanks to the help of a neighbor, a good Samaritan who was in the way. Andrea Harris was just getting off of work. He was driving by, and he saw this 94-year-old man on the ground, dogs attacking him. He said, I saw 5 or 6 dogs attacking the gentleman, and I turned around, I made a U-turn, and I stayed on my horn. When I first turned around to try to get the dog's attention, and I drove into the yard, and they were still on top of him, and he was kicking, and I was blowing my horn, and I drove all the way into the yard until the dogs moved back from him. He said, I didn't have any weapons, nothing to protect me but a long umbrella. That was all that I had. The dogs in question apparently owned by the neighbors of the 94-year-old who was attacked. David Waldron is the gentleman's name. Neighbors say that this is not the first time that the dogs have caused problems. They've actually attacked livestock in the area, according to other neighbors. Zachary Police Chief David McDavid says that animal control stopped by to pick up some of the dogs that attacked Waldron on Monday morning, but they are not sure if they have managed to round up all of the canines. So in the right place at the right time, willing and able to do the right thing to, really likely save the life of this 94-year-old who was attacked. All credit to Andre Harris for his very, very good deed. All right, that is going to do it for this edition of Bearing Arms Cam and Company. I want to thank you for being a part of the program, as always. Tomorrow, scheduled to speak with Mr. Philip Smith. He is the head of the National African American Gun Association, and looking forward to our conversation. Don't forget, you can subscribe to Town Hall Media on YouTube. That way you'll never miss a Bearing Arms Cam and Company. You can also subscribe on Rumble to Bearing Arms Cam and Company, or Apple Podcasts, Amazon Podcasts, Spotify, SoundCloud, Stitcher, townhall.com's podcast page as well. We try to make it very easy for you to access the program, and we certainly do appreciate your support. Until we talk again, be well. No. See, I almost got ahead of myself. Be well, be safe, and be free.